the first to know Nsem-Pii TV.
Sir Nsem-Pii for any ahwefo ebekaya. Abana NDC Amonioko led by His Excellency John Dramani Mahama ewo opposition na on campaign yemu no na oisiki se Ghana for be man akwanya biem no abaye Ghana mampani abana e head to election 2024 ne campaign yemu no na assemble akọ ode to dwa ene se on de se yeme na dom na obeye Ghana mampani biem oba eye former Chief Justice Torkonoo then time Chief Justice ontimi ene ne nya adwuma oba obeyi no afro no appoint obfufro ampa His Excellency John Dramani Mahama ne NDC Amonioko no ba mu no anteki omo 2 months mpo ana say we receive petition petition say yenyi ye maame Chief Justice Torkonoo enfri ho ema petition of any petition command the Poaman committee ena namso ema suspended former Chief Justice Torkonoo at that time no Chief Justice na abra suspended former Chief Justice Torkonoo no ana ye maame former Chief Justice Torkonoo and lawyers the case we ekopemu the Ecowas court say omonka bi emano nene na ye sorry ya NDC Amonioko no din sem tudwa ama Deputy Attorney General Dr. Nsem-Pii the attorney social media platform ina say ene Ecowas court dismiss Torkonoo application for provisional measure nemo and 2 interlocutory rulings and a court no the Ecowas court efa Torkonoo case we ho one say omo dismiss Torkonoo application for provisional measures no and 2 Torkonoo prima facie raise issue say substantive matter ne the court no ehwe na omo nka eho asem ama the Ecowas court ajetum say no de ombeka eho asem and omo order attorney general AG ayine say on file and respond in 30 days enti ene de court wo na Ecowas court den Nsem-Pii na na esisi o de yenjebre niente former attorney general Ayiko Otu no so ye former Chief Justice Torkonoo ne lawyers for ni bi abroad de nsebo nyina to dwa no ni obi
so give us an idea, what was the ruling from the Ecowas court today?
Well, I have been saying that. In fact, I don't think what has happened is even newsworthy. Newsworthy in the sense that when a government as well as the committee started doing things which will prejudice
FM.
Some of us sounded the alarm bells. You see, if you remember, they had not finished hearing all the petitions. Out of the 3 petitions which His Excellency the President asked them to inquire into, they inquired into only one. And in an indecent haste, they rushed and went and presented a report to the President. The same day, the President said he had accepted the recommendation that the CJ be removed. When indeed they had not finished doing the other, petitions or inquiring into them at all. So if you are given 3 petitions and you finish one, where is the evidence that you have complied with the orders given to you or directives issued to you? Now, we did say that there were cases pending at the High Court and the Supreme Court, and that it would be better for all these things to be cleared out of the way before government embarks on making a nomination to the position of Chief Justice. The government didn't listen to us. It made a nomination. When a person was to appear before Parliament, alarm bells were raised in Parliament. The minority stood their ground to say that what we are doing is not fair. There are cases pending at the High Court, Supreme Court, and Ecowas Court. So stop it. Just respect the boundaries of authority. The case is pending before the judiciary. You are the executive. Just respect the boundaries. The legislature, which is also an arm of government, can also hold on to respect what the judiciary will say. They will have none of that. And I went ahead, bettered him, and issued their report recommending him. Before anybody could say Jack, they went ahead and swore him in. You see, when you do these things, you are fixing the judiciary with a fiat accompli. That's all they have done. That's why I'm saying that I don't know what they are celebrating. Because for all intents and purposes, as we see today, they have a new Chief Justice. So if they grant an injunction that the removal or the suspension of the former Chief Justice is not proper, would they reverse everything? Would they reverse it?
Yeah, but
so they are saying that for purposes of the interim injunction, let it go. What is newsworthy is the fact that they made a preliminary determination that indeed rights have been violated, and that the Attorney General is given 30 days to respond to the substantive matter, to give them an opportunity to hear the case. That is not an interim matter. That would be the substantive matter. So once a substantive matter, a judgment is given which says that whatever they did was wrong, it will be left to the president. And here is Attorney General going about saying that whatever the courts will say, they will abide by it. I hope you have heard that one.
Yeah, I have.
So we are not worried about anything. In fact, to make the point that in October, lawyers wrote to the Ecowas court to say that the things have taken so long and that we are no longer interested in the interim measures.
Okay. And
that they should rather give us a date.
For the substantive issue.
Those letters are also being circulated.
So for you as counsel, you were expecting the kind of ruling from the court on the application for interim measures, that the court may come to the conclusion they came to today, right?
Saying that we had even written the Nigerian solicitor, Falana, to the court already.
Okay.
And they should not waste their time on that matter, but should rather proceed to consider the matter itself.
Okay. And you had also applied for a default judgment. Is that the case?
Because they have refused to file their response from the time the matter went there.
Sure.
You remember recently in Parliament, Afenyomakin made that point that they waited when the Chief Justice nominee was to appear. Then the Attorney General went to court to say that he wanted extension of time, and he was given 3 weeks to go and file it. So although they have been going about telling everybody that indeed there are cases pending before the Supreme Court, they had in fact not responded to any of them. They had not responded.
But
so this is nothing. I mean, I don't know what it is that we are talking about. Let me read this one to you. We have a little time. Re-suit number 6 and so Torkonoo of the Republic of Ghana notification on breach of lease pending on request for date to hear substantive suit. The above subject matters referred is we are counsel representing the plaintiff in the above reference suit. The plaintiff commenced a suit seeking the enforcement of fundamental rights in relation to a position as a substantive Chief Justice of Ghana on June 30, 2025. Although the defendant was served with both a substantive suit and motion for interim measures, the defendant state elected to respond to the interim measures that were held on July 14, 2025. despite the pendency of the suit challenging the plaintiff's suspension and seeking an order to restrain the defendant state, the President of the Republic removed her as the Chief Justice of the Court on September 1st. That time, the motion had already been heard. He went ahead and removed her. Thus, this Honorable Court has been presented with a fiat in an apparent move to present this Honorable Court with a fiat complaint and thereby undermine the independence of the judiciary. Even though the defendant has disregarded the higher principle of least spending, the ruling of this Honorable Court on the provisional measures, by mark my words, will no longer be necessary. Let me repeat it. The ruling will no longer be necessary as it has been overtaken by the contemptuous act of the defendant. We are, on account of the foregoing, compelled to request for the shortest possible date to hear the substantive suit. So what are they celebrating?
Oh, okay.
What are they celebrating?
And I think what also generated this controversy was in an attempt to update the rest of the country on what happened at the Ecowas court, the Deputy Attorney General concentrated on the court's ruling relative to this, interim application, i.e. the one seeking provisional measures. And in his update, he made the point that the court has thrown out that application. In that update as well, he didn't touch on, the fact that the court has ordered the Attorney General to file their response in 30 days relative to the substantive matter. And that's what I think has created this whole, controversy on social media especially.
Well, they are playing politics. It's always in politics. So they are just playing politics. Just as they told everybody that they cannot work with her, they cannot reset the judiciary with her, and then when they come, they will remove her. So the whole thing was just trumped up. Got some people to write some petitions, quickly got others, the Council of State, to say we have found a prima facie case, and then they went ahead and removed her, set up a committee. Yeah. And you saw the reasons that were given, that they don't make any sense. How can a head of judiciary be said to have engaged herself in misconduct for transferring a worker? Not that he even dismissed the worker, but for transferring the worker. They say that amounts to, better misbehavior. And when the person in charge of the accounts, the spending officer, had explained that she was entitled to travel with other persons, they still said that for them, they owe the liable for whatever it is that has happened. I mean, you look at the grounds, there are no grounds, they are nothing. You said you have made a prima facie determination. It says, show me the prima facie determination to enable me to prepare so I can come and appear before your poor man committee which you have set up. You said you will not have none. You will not give it. So she was never given the grounds for the so-called prima facie determination. Up to today, we have not seen it.
So you are saying when she wrote to the president that she would want to be heard before the prima facie determination, the president granted her that opportunity, asked her to respond, which she did, and then the Council of State together with the president came to the conclusion that there are some prima facie determinations that have been made. You are saying those determinations and the basis of those determinations were not made available to her?
Never, up to today. And meanwhile, you know the meaning of prima facie.
Sure.
It's just on sight, at first sight, at first blush. You haven't gone into the merits, but you just say that, well, I've seen some prima facie matters. So you go and see whether you confirm what it is that are taking place or what we have seen to be wrongdoing. For example, you remember somebody said she traveled and she was giving a per diem, and that she didn't retire the per diem. It was a blatant lie. She retired everything when she arrived back here. So assuming you have used this as a prima facie determination that she has refused to retire some money's, accountable interest. Now you found that what they are saying is wrong. You understand? But you didn't show them what the so-called prima facie determination was. But yet you ask her to go and appear before a committee and answer whatever charges have been laid against her. Now, if you remember, there were over 23 or 20-something charges. In fact, they found only 3 proving. And the 3 themselves were so hollow, useless grounds, that they said they had found.
So, when you went before the committee may have read the details of the prima facie determination to your client for her response, no?
Why are you saying may have? If they do that, why would you be complete? You said they may have, which is the same as might have. So you are only pronouncing. It's not true. They didn't.
They didn't do that?
Asking them several times. I made several. Those of you who have seen the reports, if they recorded them, if they did faithful reporting, you will see it. We asked more than once, about 3 times, that we have not seen the prima facie determination, and we don't know what it is that we are answering. They won't find it. They, even at one stage, they told us that it is not for them to supply it to us. It was the president and the council of state, so we should go there.
And did you make that attempt to go there?
We didn't worry ourselves. Because if he says he has given it to them to confirm or deny whether those things are true, then they had it in their custody.
Yeah.
That is what they are going back. So they are the proper persons to give it to us.
As far as your client is concerned, I mean, based on all the pending applications before the court, which applications, if determined in her favor, would mean that her removal was unconstitutional? I get the sense that your client does not recognize the fact that there is, for the want of a better expression, a new Chief Justice in place, right?
Well, we went in court before the new Chief Justice was sworn in. So what question are you asking?
No. I'm asking...
Are you saying we have now gone to court after he has been sworn in?
No, that's not what I'm saying. I'm saying because of the pendency of all the applications in court, you disagree with the fact that the executive should go ahead and nominate, vet, and swear in a new Chief Justice.
We said all that and they didn't listen to us. So what are you saying now? They didn't listen to us. We told them to hold on. You all saw what happened in Parliament. Even today, from what we are hearing, some majority people are saying Attorney Martin has brought the Parliament to disrepute and that he should even be punished for what he did. Now, what was it that he was saying? All he said was that there are cases pending. Can we please hold on? It was not the long and short. Was that not the long and short of all that Attorney Martin was saying?
Yes.
So we said everything. They didn't listen to us.
I believe you are still waiting anxiously for the court in Ghana to fix date for the various applications before the court here in Ghana, right?
You heard Attorney Martin saying that in the Supreme Court case, just like the Ecowas, they refuse to file anything. All that they are interested in is in filing to contest interim orders. Because that one too, there was an interim application which went to the Supreme Court with the lead judgment being rendered by Torkonoo, if you remember.
Yes.
So that one, they quickly filed their papers. In the same way, when we asked for certiorari, they quickly went there. When we were not given a date, then they filed saying that the court had no jurisdiction. because the matters we are coming to talk about took place in the in camera. And they were giving a date quickly, and that one was and the case was dismissed. The substantive matter, no date was fixed. This is what we have been going through.
As counsel, would you still advise your client to really be interested in these cases now that we have a substantive Chief Justice?
That is not the issue.
Yeah,
that is rather not the issue. Yeah, the issue is that our case was pending before.
I agree. Yes, that I agree.
So we have to take all sorts of things into consideration. We can consider that as well. Whether we are not, as it were, giving them opportunity for them to rule against us and fix us again with another peer complaint in later years. So these are all matters we can always